Mr. President.
Leader of the Opposition.
Thank you, Mr. President. I lead for the opposition in debate on the Road Transport Amendment Driver Licence Disqualification Bill 2017. The opposition does not oppose the bill. The object of the bill relates to amendments to the Road Traffic Act. In particular, it deals with driver licence disqualification and also deals with other sanctions that may be imposed on drivers in some circumstances. The bill's overview particularly points to the following provisions. The bill gives the local court power to remove outstanding driver licence disqualification periods in some circumstances. It abolishes the habitual traffic offender scheme. It provides for clearer delineation and flexibility of periods of disqualification for unauthorised driving offences. It reduces the maximum periods of imprisonment that may be imposed for unauthorised driving offences, and also enables additional sanctions concerning vehicles to be imposed for unauthorised driving offences and in relation to recidivist unauthorised drivers. Many of these provisions represent a reduction in penalties. Some provisions increase sanctions, but on any objective view they are outweighed by the provisions which soften the impact of sanctions and disqualifications. The attorney in the other place, and no doubt Parliamentary Secretary here, in their second reading speeches placed emphasis on the origin of the legislation in report number 3/55 of the Legislative Assembly Committee on Law and Safety, entitled Driver Licence Disqualification Reform. The committee made what can be described as sensible comments about the disqualification regime. The current system has mandatory disqualifications that cannot be made to fit the circumstances of particular cases. Some of the lengthier automatic disqualifications are disproportionate. Unauthorised drivers are not necessarily dangerous. 700 persons were imprisoned in 2012-13 for unauthorised driving offences. The lengthy period of disqualification is ineffective as a deterrent, and in the year before the tabling of the report, 52% of people who had their licences cancelled had this occur because of the non-payment of fines for offences that had nothing necessarily to do with traffic matters. The Sentencing Council in 2006 issued an interim report entitled, and I quote, "The effectiveness of fines as a sentencing option, court-imposed fines and penalty notices," unquote. That report was critical of the habitual traffic offender scheme, and the bill abolishes that scheme. There are currently about 17,000 people who are declared habitual offenders. No other state or territory in Australia has that scheme. The scheme is in Division 3 of Part 7.4 of the Road Transport Act and was previously in the Road Transport Drivers Licensing Act. It's a good example of the behavioural psychologist approach taken by what is now Roads and Maritime Services of merely piling on extra penalties with no discretion to try and force behavioural change in individuals. However, the real world is neither that simple nor that simplistic, and despite the support given to such a view by both houses over many years. Schedule 1.14 repeals Division 3 of Part 7.4 of the Principal Act, the portion that contains the habitual traffic offender scheme. Schedule 1.15 provides a mechanism to remove some driver licensing disqualification period. Proposed Section 221B provides that the local court may, on application, remove all licensing disqualifications to which a person is subject if he or she has not been convicted of any driving offence during a relevant period. The court must take a number of factors into account. These include the safety of the public, the whole of the driving record, any conduct of the person after the disqualification, the nature of the offence giving rise to the disqualification, and any other relevant circumstances. That last category is itemised to include the impact of disqualification on the person's capacity to carry out family or carers duties and to travel for employment, business, education or training, and bearing in mind the applicant's health and finances and the availability of alternative forms of transport. Mr. Deputy President, these are all very important, relevant factors. The local court must consider that it's appropriate to order the removal of restrictions. Section 221D provides that a person cannot apply for a removal of disqualification if he or she has been convicted of one of a number of specified offences. These are generally more serious offences and do not have to be the offence generating the disqualification. They include murder or manslaughter by use of a motor vehicle, an offence comprising or including causing death, grievous bodily harm or wounding by use of a motor vehicle, predatory driving, driving recklessly or at speed or manner dangerous in a police pursuit, negligent driving causing death or grievous bodily harm, intentional menacing driving, or failing to stop and assist after a vehicle impact causing death or grievous bodily harm. Schedule 1.16 and 1.17 clarify aspects relating to immediate licence suspension notices. Periods of disqualification and sentences are reduced and moderated in the bill. Section 53.3 of the Principal Act is amended so that the maximum period of imprisonment for driving while never having had a licence is reduced from 18 months to 6 months. The automatic disqualification of 3 years for a second or subsequent offence in Section 53.4 is abolished. Section 54.1, subsection 54, subsection 1, subsection 3 and subsection 4, which deals with driving while disqualified or suspended or having a licence refused or cancelled, are amended by reducing the maximum penalty of 2 years to 12 months and 18 months to 6 months imprisonment. Section 54.5, which deals with driving while a licence is cancelled or suspended for non-payment of fines, is amended by removing imprisonment altogether for a first offence and reduces the maximum penalty from 2 years to 6 months for a second or subsequent offence. New Section 205 capital A provides default and minimum periods of disqualification for various unauthorised driving offences. Currently, automatic mandatory periods are applicable. This provides greater judicial discretion so that punishment can be made to more appropriately fit any crime, something that I think most honourable members will agree with. Driving while disqualified is sensibly is treated more severely than driving while a licence has been cancelled. The minimum period of disqualification for Section 53.3 second and subsequent offence is 3 months. In Section 54.1, 3 or 4, the first offence minimum is 3 months. In Section 54.1, 3 or 4, the second offence is 6 months. And in Section 54.5, the first offence is 1 month. And in Section 54.5, the second or subsequent offence is 3 months. Schedule 1.12 inserts a new Section 207 capital A, the effect of which is that the disqualification periods are concurrent rather than cumulative, unless the court specifically orders otherwise. In practical terms, this reduces the likelihood of absurdly long disqualification periods. Schedules 1.18, 1.19 and 1.20 increase sanctions and actions against disqualified drivers in contrast to the other provisions in the bill to which I have briefly referred. This will amend Part 7.6 of the Principal Act, which deals with sanctions concerning vehicles, that is, sanctions applied by the police. Section 239 sets out the sanctions applying to sanctionable offences, most notably a 3-month vehicle sanction. Section 238 is amended by including among sanctionable offences when a disqualified driver is caught exceeding the speed limit by more than 30 kilometres per hour, or when a person is charged with driving while disqualified or unlicensed 3 times within 5 years. Section 239 is amended so that in these cases the 3-month sanction period is extended to 6 months. Section 242 provides for the impounding of vehicles that are caught by the sanction period. Section 248 provides a 3-month impounding period. The bill amends Section 248 to provide an extension of the 3 months to 6 months if the driver was disqualified and the sanction was imposed for a sanctionable offence committed by the driver. I note that these provisions under Section 249 are not altered. The current provisions concerning vehicles in these situations that are not owned by the driver concerned are also not altered. As I indicated at the outset of my brief remarks, the opposition does not oppose the bill. I note, and won't go into or won't repeat, but I note in particular the comments made in the other place by Mr David Harris MP, the Shadow Minister for Aboriginal Affairs, about the particular relevance to Aboriginal Indigenous persons of many provisions in the bill, and I would urge honourable members to reflect on those comments made by Mr Harris. The measures in the bill we think are sensible and balanced and should be supported.
The Honourable Reverend